Hello everyone, welcome to the webinar today. I'm joined by Mark Peston. Hi Mark.
Hi, Mena.
The webinar today is about pensions. It's part two, which should lead you to believe that there is a part one, which there is. Mark's going to tell you where to find everything when he starts. I'm just going to talk you through the tech this morning. Um, If you've got questions, then you should have a box that you can type your question into. Don't be shy. I am not going to publish the questions so other people won't know the name of the person who's asked the question. I will interrupt Mark at a suitable point and put the question to him and he will answer the question. You should also see that there is a little box that says handouts, and Mark's slides are available, so if you want to download those, now's probably a good time. I will remind you a few slides before the end. And in terms of continuing professional development, if you are still on an hours-based CPD scheme, then you can claim 1 hour CPD for watching this webinar, whether you watch it live or whether you watch it on the YouTube channel or on our website. You can still claim the full hour. There isn't a code or anything. It's just an hour for watching this pensions webinar, and you can put in the title when you do your returns. So I think that's all the housekeeping. We've got about an hour with Mark, so I will hand over to you, Mark.
Hi. Right. Uh, as Mena mentioned, this is part two of the sessions on things you want to know about pension and pension sharing. I didn't want to ask. The agenda is I'll run through briefly. We did a pension letter of instruction webinar a few months ago, and I think, Mena, that's on your website, isn't it?
Yeah, that's right. It's on the website, and we've got a YouTube channel under my name so that you can catch it anywhere.
Yeah, that's good. So I'm just going to revisit that for those people who haven't heard it before. We're going to talk about equality of income or capital and how that and how we approach that. I'm going to talk about what the pension expert needs, and actually I'm going to talk also about the difference between an IFA and an actuary. A couple of thoughts on offsetting, which is a big subject on its own, but I'm just going to give you a couple of thoughts on that. How we think you can get good outcomes by using a pensions expert. Mena suggested that we talked a little bit about judicial separation, which we've come across occasionally, and I'm going to be talking about timing of the decree, absolute and pension sharing order, and then a little bit on finishing the job, getting the pension share actually implemented. So just a couple of quick slides on BlueSKY. We're chartered, we are a firm of chartered financial planners. Back in 2000, when the legislation changed, where we can now share pensions, that's when we first started to get involved in the pension sharing world. We've now got the 4 financial planners that you see there on your screen on the left. Those 4 people are involved in pension sharing work. And plus we are supported by technical people and admin people behind the scenes who also help us with our work. So it's quite a major stream of our business.
And one of the things that we've said before, Mark, but I think is worth repeating, is that the fact that you aren't actuaries doesn't prevent you from preparing the expert's report or acting in the capacity as an expert, because you are, of course, resolution accredited and you have been doing this for years.
Thanks, Mena. Yeah, you're absolutely right. In fact, one of the slides I'm going to go through does actually answer that regularly asked question
Yeah.
about, well, what is the difference between an IFA and an actuary? And so we're going to talk about that. We've kind of agreed on the term expert as being able to refer to the IFA or the actuary. So, but we'll come to that. So briefly looking at the letter of instruction, I thought that to put it in context, I'd just sort of articulate how we see the pension sharing process as IFAs, and it's broken into three. We see it as broken into three parts. So initial inquiries that we get, we then often get instructed to prepare a report, and then that might follow through all the way through to implementation of the order. And the initial inquiry we view as very important in the process, particularly where we're able to discuss the case with the individuals concerned or with the lawyers representing them. And it doesn't happen in every instance by a long way, but the more we can engage with the lawyer or the clients concerned, the clearer we become, and the more direction, the more helpful direction I would propose that we can give in how the pension share should be constructed and delivered. And I think that bit is very helpful. The general principles for the letter of instruction is, of course, what are we trying to achieve? And I think looking at some of the letters of instruction we get, it's perhaps not entirely clear that the instructing lawyer sometimes knows themselves what they're trying to achieve, so they just ask a whole barrage of questions, hoping that somewhere in the report will throw some light on what it is they're trying to get. Generally, the objective is to create equality of income, and I'm going to talk about the difference between equality of income and capital. It's normally to produce equality of income when all benefits have become payable, and by that I mean the state pension. So we would normally look at creating equality at state pension age, because of course if you create equality at 60, once state pensions come into payment, that might undo the equality that you endeavoured to create. So we generally would like to look at state pensions as well. One of the more awkward pieces of work we get is to look at benefits that have only accrued during the marriage.
Are you finding that you're being asked that more now?
I don't think it's more. I just think, I don't know, 5% of the cases, 5 to 10% of the cases, they say, you know, could we look at benefits only accrued during the marriage? And of course, if you've got a 20-year marriage, what you need to know is, well, if you only want us to look at benefits accrued during the marriage, we would need to know what the situation was when they got married.
Yeah.
And first of all, the clients rarely have that information, and the pension trustees we've never found a pension trustee who can give us historic pension information. They just don't have it, or are unwilling to give it. We've never managed to get it. So in these cases, we have to make guesstimates. They can be reasonable guesstimates, but they are assumptions on how that pension will have looked 20 years ago.
Sure.
So not very easy. We're going to talk about offsetting considerations, but that's what you might put in your letter of instruction. And something which we touched on in the last seminar as well is sometimes, if with the greatest respect to all lawyers, if they don't quite know what they're trying to achieve and they ask just a load of questions, then sometimes what's produced is a big grid of results. And probably about 3 or 4 years ago, we had an instruction from a lawyer that when you analysed it, it was actually asking for 120 different permutations. And of course all you get then is a grid which you're going to include in your report, and one person is going to want the big figure and the other person is going to want the small figure, and I think you divert the focus of of the conversation about how pensions should be divided away from what the objectives are, just to the size of one figure versus the other.
Not helpful.
And on the instruction stuff, we prefer single joint instructions rather than single instructions, because we think they're more useful. They're about the same cost, so we always say to people, look, you could instruct us on a single basis, but I don't think your report is going to be taken very seriously by the other side, and you might as well try and encourage the other side to get a report, because the cost's about the same.
Yeah, and then you can share the cost of the report with the other side if it's a single joint expert instruction.
Absolutely, yeah. And typical contents we're looking for is, we want to know obviously who the clients are and who's acting for them, what stage you are in proceedings, a brief resume of the client's situation, so we don't need to know everything but just the pertinent bits, and the clear instructions, and as we said before, there is a draft letter instruction on not only Mena's website, but our own website as well. It's the same draft letter.
And that's the letter that accompanies the webinar that we did. So if you're not sure, you could download the letter, and then if you didn't know how to fill it in, Mark and I spend an hour going through how to draft that letter of instruction so that it's perfect.
Indeed. Indeed. If there are timescales to bear in mind, then let us know. We can't deal with every case on an urgent basis, but we do try where possible. And you'd obviously be wanting us to tell you what the costs are to produce a report, and in very broad terms, our cases would range probably between £1,000 and £2,000, with probably the average being £1,500–1,600 to produce a single joint expert report. And the actual data needed within your letter, dates of birth, smoker status, statement of health is important, and as a minimum, if you can access the last statement your last pension statement your clients have got, that's also useful too.
Mark, just pausing on that last item, the last pension statement, you're not saying you need up-to-date CE values, are you? You're saying give us something, and then you're going to contact the pension experts with a signed authority. So you prefer collecting your own data, don't you?
We do. We do. The preference is that because we find that pension trustees, if you write to them, they'll send you a standard letter. They invariably don't include all the data we need to do the number crunching, so we end up writing back to them anyway. And so if possible, we would write away. If you do have information and it's within 12 months old, within 12 months, we're happy to go on that if we can. Sometimes we can, sometimes we still have to go back and ask further questions.
Thanks.
Very briefly, the sort of instruction wording, the starting premise is, in our opinion, let's have a look at how you can create equal incomes for the couple, and sometimes there may be other questions like offsetting. How would the share required to create equality of income be adjusted in lieu of one party or the other having more cash or property equity? And the other questions you might put in your letter might be things like how much, you're not looking at equality of income, but you're looking at how much pension share is necessary to provide one party with a certain level of income. So that's the sort of stuff. So moving on to equality of income or capital. This is something that I guess regularly come up against questions, and where we get clients that actually come into our offices and excuse me, meet us, We often, in our meeting rooms, we have whiteboards, and we'll often start, if you like, with a Janet and John approach for the clients, who often are at sea with their finances, and certainly one or sometimes both don't really understand it. So the starting principle is we draw 3 boxes on the whiteboard and say, look, your finances typically will probably fit into one of these 3 boxes. It will be your house, the family home, every other investment or rental property or business or anything else like that goes in the investment box, and then pensions will go in the 3rd box, and they're all different assets. And the starting premise, of course, is to say, if there are enough funds, well, let's just divide everything down the middle. We do draw a line above pensions because specifically pensions are there to produce income. They're income producing products, that's their function, and certainly when you get involved with final salary schemes and mixtures of schemes, you just can't divide them as capital. So whereas you can divide the above the house and investments as capital, so 50-50, you have to divide the pensions to produce an income. And I will be returning to that in a moment. And a consequence, if you do choose to divide the pension on a capital basis, then these are admittedly extreme examples, or this is certainly an extreme example. This is the Armed Forces Pension Scheme, which along with all the other uniformed service schemes are a little bit of a dark art, but this is clearly counterintuitive, but we do have a working document as to how this is worked out, because we have been asked about this several times. But if here is a couple who were dividing their Armed Forces Pension Scheme CE 50-50, and in this instance the husband's income was about £2,000 per annum and the wife's income was £16,000 per annum. An extreme case, unlikely to happen, but these are the actual figures from the Armed Forces Pension Scheme. My whole point here is that by dividing pension schemes based on their value alone can create unintended consequences.
I mean, it's really difficult sometimes, Mark, to explain this to a judge, where judges say, no, you're not having a pension sharing report, you can just divide the capital, to try and get somebody to understand that this could be the end result, and as you say, unintended consequences. Sometimes for solicitors it's really frustrating.
Well, well, it is, and I suppose that's our mission in life, is to, if nothing else, to try and explain to judges, and I think lawyers get it more than judges, in my experience, the danger that can be done, certainly with final salary schemes. But the next grid, it will even show this is a money purchase fund which has guaranteed annuity rates in it. Those older people amongst us may remember Equitable Life, who went under because they had attached guaranteed annuity promises to their personal pension schemes years ago, and then had to honour them when annuity rates over the subsequent years have plummeted. So here we've got a money purchase scheme with a guaranteed annuity rate attached to it, which means that when it comes to be paid, it'll guarantee a certain income which is much higher than the current market rates. So if you divided one of those money purchase schemes down the middle, you could also create an unintended consequence of unequal incomes. And that's something which, of course, I'm going to say this, but if you ask an expert to have a look at even the money purchase schemes, they will tell you whether there are any benefits under the bonnet which you need to know about.
And this is one of
So
the things that we always say, isn't it, Mark, that if you get a planner, even if it's not a single joint expert, to get involved early, then they can pick something like this up and see the value in it early, so that you haven't divided it up and then gone to someone and then they say, oh, this wasn't such a great idea.
no, that's right. That's right. Yeah. Um, the other things which will mean that you won't necessarily divide a pension down the middle from a capital point of view is if you've got Mr. and Mrs. of different ages, or there are health issues. And what we're seeing more more than ever now is that more annuities are being medically underwritten. So there's a high percentage of people who will actually qualify for enhanced annuity rates. So just winding back a bit, in I don't know how many years ago it was, a few years ago, annuity rates used to be sexed, so women didn't get as good annuity rates as men because they live longer. Well, European ruling was that you can't do that, and just like you can't differentiate for men and women in car insurance, you can't now for annuity rates either. So that's where some lawyers are thinking, well, if we're applying the same annuity rates for Mr. and Mrs., surely we can just divide a money purchase pot of money down the middle and it's going to give equal incomes. In some cases that's true, but in other cases, of course, where there are benefits attaching to money purchase schemes, or difference in age, or differences in health, that can skew the picture. Just then on offsetting, that picture before where it had the straight line, if you are now saying, well, actually we want the wife in this example wants a bit more of the property equity, and that's fine, the husband then would keep a bit more of the pension. And I'm going to talk about a different method of offsetting, because there are millions of them, but in this example, £100,000 of extra equity that the wife gets could be offset by the husband keeping 125,000 of extra pension. And the rationale here is that if the wife did say, well, actually I'm going to sell the property and therefore I've got an extra £100,000 in cash, if she could put that in her pension as a basic rate taxpayer, she is that 100,000 will be grossed up to 125,000, so she gets tax back. So therefore, it would equate to 125,000 pounds in the pension, hence creating that equality. And that's a fairly that's a mathematical way of looking at it. There are some potential problems with that, with funding. Can she get £100,000 into a personal pension because of the rules? So it depends on other aspects of their financial situation. But this is certainly one way of looking at that offsetting example. Just talking about what the expert needs, and Mena mentioned before about a difference between an IFA and an actuary, and over the last few months I've been involved in a working party that was put together by Cardiff University to help a lady called Hilary Woodward, I think it was,
Yeah,
with a paper on.
Interesting. That report's been released, hasn't it? The one that you've been involved
That's
in.
right. That's right, and it was to look at the approach to offsetting and try and start the process of getting some general principles on how offsetting should be approached, because it's widely recognised that lots of people, at least if you go to different experts, you'll get a different view on how pensions should be offset, or how you would approach offsetting and pension sharing. So the collection was probably an even collection of actuaries and IFAs. And I must say it was a fascinating debate and meetings that we've had on this. But one of the things we talked about was whether a lawyer should use an actuary or an IFA. And I think the conclusion was that the mutual agreement was that actually you could get a really awful actuary who knew nothing about the pension sharing world and therefore wouldn't be able to produce a very helpful report. And likewise, if you had an IFA who wasn't familiar with the legal systems and pensions and divorce, he also would be likely to do an awful report which might not be very helpful. So it was agreed that actually what a lawyer should be looking for is a pensions expert who is experienced in this marketplace. And there are a number of IFA firms like ourselves who do that, and there are also a number of actuaries who are also specialists in the divorce market. And so we kind of agreed to say, well, look, time out, there is no difference really between an actuary and an IFA. It is a pensions expert that you're looking for. The only thing I would add to that, which again actuaries would say, yeah, you know, they would agree with this, is generally speaking an actuary would give advice around the pension report. They can't implement the pension and they can't give financial advice beforehand. So they can obviously discuss things generically, but can't give specific financial advice. And I think the difference with a financial planner, or as we call ourselves, so we're IFAs, but financial planners, the same term, is that if we get involved in that initial discussion early, we can give financial advice to the individuals and then do the report and then even go through to implementation.
And what you mean there is you could speak to both parties, not just one party, and then become the single joint expert, just to be clear, because I know someone's going to ask that question.
Yeah. Well, yeah, we've had some great results where we've been instructed, and it's clear that one party has no idea about pensions, never dealt with them, it's always been dealt with by the other person, and with mutual agreement we've had educational meetings, if you like, or empowerment meetings, if you whatever, to have that person in to talk to them about what a pension is, how it works, how the pension sharing process is going to work and how it's going to affect them, purely for the process of elevating that person's confidence and understanding of pensions to the state that they can then go into the debate about pensions feeling a bit more confident and not on the back foot, which I think happens in many cases. So we get cases referred from many mediators, so often that's great because you get both people in the same room, but by joint agreement we can deal with one person or the other. We do full notes so that we can demonstrate our impartiality, and it has to be by agreement with everyone, so we don't do it unless it has been agreed. But we've found that gives some great results. And even one really small example where we had a client in the other day by agreement, and it was the wife, and she didn't know how pensions worked, but also had concerns about how she was going to pay her fees. And we looked at what she had, and we discussed, and it will be discussed with the other side as well, that she could, because she had a couple of small pensions, she could take some cash now out of those pensions in order to facilitate her payment of her legal fees, because they were falls under what is called small pot legislation, so she could take the money out. And that's just one really small example of how by engaging with the situation beforehand, you can alleviate one fear, which is obviously a fear of many people, is how am I going to pay the fees?
Yeah, absolutely.
So anyway, so that's the expert. Um, Talking about collecting the data, as Mena, which is covered, we do prefer to collate it ourselves, but if you can give us all the stuff, we'll obviously, before we go off and ask for more information, we'll see what you've given us. In any instance, we'll by default ask for letters of authority for each scheme from your clients, and I guess one reason why we don't ask lawyers to get the information for us is because each scheme and in each case we're presented with could necessitate us to ask for different sorts of data. The sense checking is that we rarely see errors on CEs, but we do also sense check everything that we get in to think, now, does this make sense? Does this we had a case a few months ago where someone bought in the schemes they had, and we saw that they had a Prudential AVC scheme, but apparently no final salary scheme. Now we know, and a lawyer might not know this, but we know if there's a scheme which is called a freestanding AVC, we know it will have to be attached in some way. There will be a final salary scheme behind that somewhere.
Okay.
Now we also know that it was a Prudential AVC. We know that the teachers' pension scheme offer AVC, an AVC facility through the Prudential. So we came to a conclusion. We said, well, we know there's a final salary scheme behind this somewhere, and we suspect it might be a teacher's pension scheme. And to which she said, oh yeah, I have got a teacher's pension scheme. So it's quite interesting to see the stuff you can dig up. So offsetting thoughts, I'll just repeat this slide of this is where we used £100,000 equals 125,000 because of basic rate tax relief. But just to show the weird and wonderful world that there is out there of approaches to offsetting, is this was a scheme I had many years ago, and the CE was £800,000, and we sat down and went through the various standard ways of looking at what the value of that was in the open market based on different processes of valuing it. And as you'll see here, you've got the Duxbury values it at 472,000 and all the way up to nearly £1 million, and it just shows the huge range that you can apply to a CE if you're trying to get some other valuation to it. And it's obviously just playing with figures. I think a lot of these are nonsensical and can be discounted straight away, but even with my recent experience with different IFAs and actuaries, there's quite a lot of different thought processes out there still, some of which I think are slightly left field, but there you go. That's what we're faced with.
Mark, just going back to that last slide, I think it's really interesting that Duxbury produces the lowest of all the figures. So based on an 800,000 CE, because the courts are most used to using Duxbury, that gives the lowest result, which I think was seen in the recently reported case, if I'm not wrong. And all these other values, some of them are equivalent to or even higher than the value of the original CE, which when solicitors are doing offsetting, they don't necessarily think that that is going to be the result of a question that they ask the actuary planner when they say, oh, well, what do you think the offsetting value is? If somebody came back with that top figure, the replacement value figure, I think a lot of solicitors would be really surprised.
Yeah, well, the result of this offsetting working group, and I've heard this many times before, is that it seems to me actuaries and IFAs alike dislike Duxbury intensely because it's a very crude, an incredibly crude and inaccurate method of trying to capitalize various income streams, etc. It's the assumptions made behind it are hard to understand or to get to, and it's just an inaccurate tool. So I would almost dismiss that entirely. I think the general principle is certainly with final salary schemes. If you look at the CEs for those final salary schemes, they are not big enough to be able to take and create the equal pension benefits by going to the open market. So in this, so if you had £800,000 or whatever the benefits were in this scheme, you couldn't take £800,000 and buy an annuity on the open market and get the same pension benefits that final salary scheme was giving. Lots of reasons for that. Excuse me, but
probably for another day.
Well, it's deep dark maths, and I think the principle is that final salary schemes don't generally offer very good value for money.
I also just want to say to the people who are listening that Mark and some of the other experts who were involved in the offsetting project have sort of contributed to an article that's published on Jordan's Online, which is familylaw.co.uk, and also commented on a couple of recent strange pensions cases. So if you go to familylaw.co.uk, you can see the sort of experts' views, which I found really useful. And I think, if I'm not wrong, Mark, there are 3 recent articles in the last sort of month or so that the experts have sort of given a joint view about, which I think is really useful.
Yeah, I haven't, to be quite honest, I haven't seen which one of them have been published and where. I was just involved in the input. This is another view of offsetting. I've written an article which I think will be published somewhere, but on CEs, why in some instances the CE doesn't matter, and some thoughts on offsetting. And this is an extraction from that paper, and this is another view of how you could offset the pension. Mr. P and Mrs. P getting divorced, those are their cash equivalent values to start with, and in order to create equality of income at retirement, in this instance 33.6% of Mr. P's pension would go to Mrs. In order to create equal incomes of £8,468, and that's fine. If that's what they wanted to do, that would do the job. In this instance, Mrs. P said, actually, I want some cash, I don't want that pension share. So what we did in this instance was said, okay, if Mrs. P doesn't want that pension share, she is foregoing £3,411 of pension income. And if we assume for a moment that the cash which she's going to get, she actually wanted it for a property purchase, but if we assume that the cash that that Mr. P will give her instead, she would use to invest up until retirement date and then buy an annuity. And the reason why we look at that is because you're then doing the best you can to compare like with like. These were final salary pension schemes, and as you know, final salary pension schemes give guaranteed pension benefits, not subject to investment returns or whatever. And the way we match that when we do our pension sharing calculations is always to assume an annuity purchase, because an annuity purchase matches final salary benefits. So anyway, what we did in this instance was worked out that if Mr. P gave 106,000, nearly 107,000 to Mrs. P, which she invested up to retirement, so there is a bit of investment risk up to retirement, and then at retirement bought what is called a purchase life annuity. And a purchase life annuity is identical really to an annuity, nearly identical to an annuity, but is purchased from non-pension funds. So an annuity you would buy with a pension fund, and a purchase life annuity you would buy with a non-pension fund. So if you had a lump of cash, you can buy a purchase life annuity. There are some slight tax differences, but we won't go into that now. But what this showed is that Mr. P should give about £107,000 to Mrs. P to create that, to allow for that offsetting to occur.
That's really, I mean, it's interesting because you wouldn't think that such a small pension income would result in what I would say is quite a large lump sum payment, which is, it just shows why we need you to do these calculations, Mark.
Yeah, well, you're right. And one thing to bear in mind, and it's always, if you look at an annuity rate that's applied to a lump sum of £100,000, you know, you might think, well, if I've got £100,000, I could probably get 2 or 3% in a building society. So how come the annuity rate is only 2% or something like that? That just looks rubbish. But what people need to remember is that an annuity is a promise to pay someone X £1,000 per annum forever, and in this case the reason why it looks you need such a large lump sum is because it's on an index basis. So if you had £100,000 in a building society, you get 2% forever, or whatever the rate was. If you buy an annuity for £100,000, you get an indexed income, so in 10 years time, you know, it's going to be not £2,000, it's going to be £4,000. So so that's the reason for the differences.
Yeah, surprising. Still surprising.
Now, my slide hasn't moved on. Why is that?
Is it stuck? There you go.
There we go. No, I'm not. I'm unstuck now. So getting the best outcomes. Just a few thoughts on on, I don't know, just some tips about how we can get good outcomes from the pension sharing report and pension sharing assistance.
Oh, we lost you there for a minute, Mark. Are you still there?
Yep.
Okay.
So as I said before, we need to understand what we have, or you need to understand what you have, and we can help you understand the possibilities that you have and the scenarios that you have with those schemes you're looking at. Let me move on. Sorry, Mena, things are getting a bit stuck at my end.
It's all right. It's all those fancy transitions you put in your presentation, Mark.
Yeah, I know. Yeah.
They come back to haunt you.
Well, I don't know how to work them. So consult early. This is one of the things that we said before. You know, if we can have a chat, and I know it's not sometimes practical, or you might not have time to, but if you can consult early in some way, it gives us a chance, it gives the expert a chance to either chat through it on the phone with you, or at least write a letter back to you to say thanks for your letter, but had you thought of doing it in this way or that way, because it's going to produce a better outcome. That, you know, if it's not rushed, we've got a chance to do that. We've talked about final salary schemes and money purchase schemes and the difference in the guaranteed incomes they give, and where possible we would look at a pension sharing case and try to divide the pension so that the result was that each party had a bit of final salary scheme and had a bit of money purchase scheme. let's say, because then they're sharing the risk of investment risk and an annuity risk. And that sometimes slightly conflicts with our other premise of trying to share the schemes to give the best maximum benefits for both people. And sometimes those two things work against each other, but that's what we sit and ponder, because as you'll be aware, if your clients have got half a dozen different pension schemes, there are numerous ways of sharing them, and our job is to try and share them in a manner that gives best results and shares the risk if possible. We mention occasionally about the use of cash flow modelling, which in our financial planning world with other clients we use a lot, and I know other IFAs use cash flow modelling on an increasing basis, and I think over the years this will be something which becomes part of what you would expect if you went to an IFA for financial planning. And it's very useful, or it can be useful in divorce cases where essentially both people are worried about, will they run out of income? And if I get this pension share, will I have enough forever? Or how much of a pension share do I need to ensure I'm not going to run out of money? And what cash flow modelling does is it allows you to put in all the details and model this in a graphic manner to the client, and again we've seen some pretty good outcomes. The light bulb turns on sometimes.
Yeah, and I would say that where my clients have used cash flow modelling and have sat down and said, well, how do I know I'll have enough money when I'm 92? You can put the numbers in and crunch everything and say, this is how it works. And it makes them feel a lot better. Whereas solicitors, we tend to say, well, what we've got in the pot is this. And if you take 100,000, then you've got to do with it what you can. And we don't have any real answers as to what's going to happen when you're 92, because that's not our speciality.
No. So judicial separation, I think we've had a couple of these. Mena, you were going to mention judicial separation here, were you?
I was, because this was my little pet project, wasn't it?
Yep.
I came across a number of websites, and I know, Mark, you have as well, where the solicitors were representing a kind of false presentation of judicial separation and pensions. And lots of websites will invariably say, if you have judicial separation, you can't have any pensions orders because there's no decree absolute in judicial separation, because, of course, you're not ending the marriage. What you are doing is ending the obligations that each have to cohabit with the other and be married to the other, but actually you remain married. And one of the benefits that we as solicitors who think that this is a good idea will say, well, you'll still be husband's wife, and therefore when he dies you will benefit from the widow's pension, and that's one of the benefits, and therefore it's not such a bad thing that there's no pensions orders. Whereas in fact, Mark, the situation is that there are pensions available, but you'd have to do pensions attachment rather than pension sharing.
That's right.
So then you can explain how that operates.
Yeah. Yes, we've had a couple of clients. I think I can only think of two clients who've come and said, we want to explore judicial separation on grounds of religion, and also that in one instance he thought he was quite an old man, and he said, I want to make sure that my wife will benefit from any spouse's benefits I might get from my schemes. So I'm sure all of you know you can grant judicial separation within the first 12 months. As Mena said, pension sharing isn't possible because a judicial separation doesn't generate a final decree. You can do earmarking,
also known as attachment.
Oh, thank you. Also known as attachment. And I think we also discussed, Mena, for those some people call pension sharing pension splitting.
Yes, they do, which annoys me.
so pension sharing is the same as pension splitting, and earmarking is the same as attachment orders. But what earmarking does, or attachment orders, is it's an obligation for the pension trustees to pay part of the pension income, the specified percentage, to the spouse when the member decides to take benefits. And so there is no physical split of funds. It is just an instruction to the trustees that when the member scheme becomes payable, you've got to pay this across. So it's not a clean break. It's dependent on the scheme member retiring, and if he decides to be a bit, she decides to be a bit awkward, you could have a scenario where they just defer taking benefits from that pension. And if the scheme member dies, then earmarking will finish. So there's lots of horrible things. There's taxation, which is another awkward issue. So for lots of reasons, we see, I think I can't remember the last time I dealt with an earmarking order, very, very rare, very specific situations where they might be considered. And going back, go on.
The one thing I was going to butt in and say, Mark, is that it's the only option available in judicial separation, and as I'm sure most of the people who are listening to this webinar know, very few people will opt for judicial separation in the first place. Even if it is within the first 12 months of marriage, they will probably wait the 12 months out. So we're talking about a very sort of niche scenario arising where it might be appropriate to do this type of pensions attachment earmarking order.
Yeah, yeah. And then finally on this, and this relates back to the client we had who thought that he wanted to ensure that if he died, his ex-wife, would get the spouse's benefits. And we did an exercise where we wrote to all of his pension trustees to say, if Mr. Gets judicially separated, how would you treat spouse's benefits and any other retirement benefits? And I would say most said, no, we won't pay spouse's benefits. Some were non-committal to say, well, we'll tell you at the time, which was quite unhelpful. But as a result of this, he then decided, this individual decided to go through the formal, the whole divorce proceedings rather than judicial separation, because he wasn't comfortable that that these schemes would actually pay his ex-wife, the benefits if he were to predecease her. So, so you also have to be aware of that, of course.
Mark, we've got a question, if you can bear with.
Yeah.
So surely the alternative to pensions attachment in judicial separation is to do nothing, have a spousal maintenance order and claim widow's benefit on death. And I think that the person who asked that question maybe started typing that before you raised that last point, which is that sometimes the trustees won't pay the spouse's benefit on death to the, let's say, ex-wife in the scenario that Mark just put, because they're no longer cohabiting, they're no longer together. And actually, if that chap who wanted to benefit his wife had started cohabiting with another person, then on his death, that person he was cohabiting with could have put in for the spouse's benefits, couldn't they, Mark?
Yes,
even though
and that was
married.
Yeah, and that was exactly the case in this scenario, actually. That's what his concern was, because he did start cohabitating with someone who was very wealthy, had no need for his spouse's benefits. But when we did the research, the trustee would say, well, if they're judicially separated, we view them as separated, we won't pay any benefits, because, of course, their definitions are, and the trustees make the final call on this, but their definition is we'll pay spouses benefits where there's a need. If they don't think there's a need because they're not cohabiting, then there's no benefits.
And I've come across this as well. So the person who's just asked that question just be a bit careful. They've asked a supplemental question as well. So the supplemental question is, how would that work if the husband had undertaken to nominate the wife for widow's benefits?
Yeah, and that was the case in this instance, because you see, he had nominated his wife as a beneficiary on all these schemes, and some said, well, yeah, but that's not the rules of our scheme. If they're not cohabiting husband and wife, that doesn't fit our rules. So it's a great question to ask, but the pain you have to go through is to write to each trustee and say, how would you treat the spouse's benefits or death benefits, widow's benefits, if the member died? You have to do that because each trustee has a different view, and of course some will hide behind, if that's probably a little bit unfair, but they will say they will make the judgment at the time depending on the needs of the case.
Yeah. So we're flagging this up now because this is something that doesn't happen very often, but actually doesn't work in the way that perhaps we think it's going to work. Because
Indeed.
solicitors will say, well, if you've signed the form and you've nominated the benefits, then that's it, done and dusted. But actually, the trustees act on the rules of the scheme, and it's in their discretion who they pay out to.
Yeah, and the clue is on that that last question is when you join a final salary scheme, or even if you have a money purchase scheme, there is always a form you'll be presented with. It'll either be called expression of wishes, or request to the trustees, or nomination to the trustees, or nomination of beneficiaries. It's not an instruction, because the construction of pension schemes is that there are trustees, and the trustees always make the decision about where benefits should be paid. They will have regard to the expression of your wishes, but they are not bound by them.
The other thing that this person who's asked the question has said as a final observation, I think it's not really a question, is that the pension trustees can ignore an order of the court. Well, actually, they're not ignoring an order of the court, are they? Because that spouse's benefit isn't an order. The spouse's benefit is, as you've just said, is a nomination. It's not an order, is it, Mark?
No, that's right. That's right. So I think it's a separate, it's a separate issue. Yeah, a nomination is a nomination. It's a request to them to pay the benefits in a particular direction, which they don't have to do.
Great, thank you, Mark.
So moving on, timing of the decree absolute and pension sharing order, and we get quite a lot of cases where we're asked to implement a pension share, and we see that the decree absolute and the pension sharing annex has been dated on the same day. And the issue that creates is, and again, apologies, some people know all this, but some people don't necessarily know this, that the pension sharing annex doesn't come into force until 28 days after it's been dated. Now, if you date the decree absolute and the pension sharing order at the same time, the decree absolute has finalised the separation, so the spouse is no longer a spouse. Pardon me. So the spouse can no longer get spouse's benefits that once the decree absolute is dated, but there is a situation, of course, where if the member dies between the date of decree absolute and the date the pension sharing order becomes effective, there are no spouse's benefits payable, and then there's no pension share which is happening, because it is now non-effective. So in the 16 years that we've been doing pension sharing cases, we've come across 2 of these where a member has died between the date of decree absolute and the pension sharing annex becoming effective, and it causes a lot of problems. So the answer,
to add that it's negligent on the part of a solicitor to do that.
well, I think, yeah, I think this is clearly where when we do workshops with law firms, it's sometimes we see a couple of white faces in the in the audience because they're thinking through the cases they've done and whether they've stuck with this. And normally it's all right, but of course sod's law is this, this is where it could go wrong, and there's a simple way around it, and that is get the decree absolute or hold on to the decree absolute for 28 days, so the pension sharing order, once it's been dated, you wait the 28 days, it's now effective, and then you do your decree absolute. And I know it takes what some people used to use as one step in their process. It's now 2 steps, but it can save some embarrassment.
I would also say that what I've done is I have a kind of standard recital that I use, particularly if I'm acting for the recipient of the pension share, and I will say that the petitioner won't apply for 28 days to stop somebody else from applying if they don't know that this is a possibility.
Yeah.
But just to give you a warning, it's an hour in. We're going to carry on to the end, but obviously, if people need to go, then we will send you a link to the recording and you can watch the last few minutes, but we'll just finish off the final slides.
Yeah, this is actually the final slide, and this is just finishing up on the implementation. It's a slide. It's a very small soapbox, I suppose, is because who do you get to implement the pension sharing order? My view is that yes, other IFAs can do it. It will need financial advice invariably to implement an order, but an expert, I think, is needed, because if the pension expert understands the divorce process and the issues that are involved in it, then they'll be aware of the needs. They'll probably be a little bit better at approaching a divorced client, because they'll understand where they are in the process and what issues are present themselves in the process. They'll also be aware that in some cases there are internal or external options for a pension share, so sometimes it can be paid to a personal pension, or sometimes there is the option or insistence to keep it in the scheme. Now, someone who's aware of pension and divorce matters would be able to deal with that. And of course, as we said before about cash flow planning, and if you've got someone who understands financial planning and divorce, they will know the context within which a pension sharing order it needs to be implemented to create needs for a divorced person. And one thing we do is provide ongoing servicing and advice for our clients. So that's pretty much it. So we're 2 minutes over the hour. In your pack that Mena's attached, there's a couple of slides just about the pension changes in 2015, which I won't go through, other than to say good old George Osborne did bring some great flexibilities to pension schemes, and this is money purchase schemes, which adds another avenue we can go down when we are considering how to share pensions. So the necessity for financial advice on sharing pensions, I think, has taken another step up. It's a subject on its own right that we do sessions on. And then Mena was going to mention,
Oh yeah,
we're
our
on.
new package. Thank you, Mark. Thanks very much, Mark, for spending another hour with us. Obviously, this is going to be made available as a recording, which will go on our website and our YouTube channel, and Mark will have it as well. We're offering an online competence training package, so that if you are a solicitor and you're looking at CPD for the next year when the new scheme is going to be mandatory, if you don't know about it and you want to know about it, we've got a special introductory offer on our website at the moment. It's a 9-webinar package where I take you through the new competence scheme. The introductory offer is £175. If you purchase before the end of March, you've got 6 months to watch the webinars, which takes you up to October. So if you're not going to think about it till October, you might want to put in for the webinar package, and the link is there. So if you're interested in that, have a look at the link, have a look at our website. Otherwise, our details are available. Mark is obviously at BlueSKY. I'm at Law CPD Solutions, and if you've got any questions following this webinar, then please email. There is one pending question outstanding, but I'm going to answer that question by email to the person that's asked it. Otherwise, those are Mark's details, and as he said, he does provide training for solicitors, so if you're interested in finding out a little bit more about something that he has talked about and you want him to come in, I know that Mark is very flexible and that he will do that, so do contact him. If you've got any training questions, then obviously throw those in my direction. Thank you very much, everybody, for staying with us, even though we've gone a few minutes over. Thank you very much, Mark. If there are any questions, obviously I'll let you know. And thank you.
Good, thanks, Mena.
Thanks very much, everyone. Goodbye.